You've probably watched one of those American videos. A lawyer, very confident, telling you the clever move when the police pull you over and want you to blow into a breathalyser. Give them nothing. Refuse. No sample, no evidence, no case. And if you ever try that clever move on a British road, you will hand yourself a criminal conviction, a driving ban of at least a year, and quite possibly a cell, for the refusal alone, whether or not you'd had a single drink. That is the trap I need to talk to you about today, because it's one of the few situations in British law where doing the thing that feels smart is far worse than doing the thing that feels frightening. And the people getting caught by it are, more and more, the ones who've been quietly absorbing advice made for a completely different country. So picture the moment. It's late. You're driving home, maybe from a dinner, maybe from the pub where you had one, maybe from somewhere you had nothing at all. Blue lights come up behind you. You pull in. The officer walks up, and after a question or two, he holds up a small device and says the line, "Provide a breath sample now, or I'm arresting you." And everything you've absorbed from the internet says the same thing. Don't blow. Don't give them anything. Make them prove it. Your stomach's telling you the machine is the enemy, and the smart people refuse it. Here is the truth almost nobody in this country understands until it's too late. In Britain, refusing that test is not a clever way to avoid a charge. Refusing is its own charge. And it is punished as if you had failed the test, as if you were over the limit, even when you weren't. So in the next few minutes, I'm going to give you one calm approach and a specific thing to say that protects you properly, not the American way, the British way. It keeps you out of the refusal trap. It pins down exactly which test you're being asked for, and it puts the one thing on the record that actually helps you later. And I'll show you the exact law so you understand precisely why refusing is the mistake. And stay with me right to the end, because there is one, and genuinely only one, narrow situation in British law where you can decline to provide a sample and be on the right side of the line. Almost everyone gets this wrong and thinks it's a loophole they can use. It very nearly never is, and I'll tell you exactly what it actually is, so you don't reach for it and destroy yourself. I'm Oliver Bennett. For 15 years, I defended people in police stations and courtrooms across England and Wales, and failing to provide a specimen is one of the saddest cases I dealt with, because so often it was somebody who'd had very little, panicked, refused on principle or on bad advice, and ended up worse off than if they'd simply blown. This isn't legal advice, and it isn't me telling you to fear the police. It's the plain English version of what I wish every driver in this country understood before the blue lights ever appear. Let me start with why this matters so much more than people think, because the stakes here are genuinely severe. A drink driving related conviction in this country is not a slap on the wrist. It follows you. It means a driving ban measured in months or years, an unlimited fine, a criminal record that shows up on background checks, and an insurance premium that can double or triple for years afterward. For a lot of people, it means their job. Anyone who drives for a living, and plenty who just need a car to get to work. And a failure to provide conviction carries the same ban as being over the limit. So this is not a technicality you can shrug off. It reshapes your life for a good while. And let me be fair, because this channel has never been about painting the police as the enemy. Drink driving is not a victimless technicality. It kills and maims people every year. And an officer who takes an impaired driver off the road at midnight has genuinely protected someone's family. The breath test exists for a good reason, and most of the time it's used properly against people who are, in fact, over the limit. My argument has never been that you should try to beat the system. It's that a sober or borderline person who panics and refuses on advice built for another country ends up convicted when they didn't need to be. And that is a tragedy that's completely avoidable if you simply understand how our law works. Now let me do the law, plainly, because there are two separate tests, and the whole trap lives in the difference between them. The first is the roadside test, the little handheld screening device. Under Section 6 of the Road Traffic Act, a police officer in uniform can require you to take a preliminary breath test if he reasonably suspects you've been drinking, or that you've committed a moving traffic offence, or that you were involved in an accident. That's a low bar, and it's meant to be. This is just the screening stage. Now you can refuse this roadside one, but understand what that costs. Refusing the preliminary test without a reasonable excuse is itself an offence. It carries a fine of up to £1,000, 4 penalty points, and the court can disqualify you. And here's the part people miss. Refusing it doesn't end the encounter. It triggers the next stage. Because if you refuse the roadside test, or if you take it and it's positive, the officer arrests you and takes you to a police station. And the police station is where the real danger lives. This is the second test, the evidential one, under Section 7 of the Act. At the station, you're required to provide an evidential specimen, usually breath on a bigger calibrated machine, sometimes blood or urine. And failing or refusing to provide that specimen without a reasonable excuse is a serious criminal offence in its own right. The law treats it as equivalent to being over the limit. That means a maximum of 6 months in custody, an unlimited fine, and, this is the one that gets people, a mandatory minimum disqualification of 12 months. Mandatory. The magistrates don't have the discretion to let you keep your licence. And I want you to understand this isn't only about alcohol, because a lot of you have asked me about drugs, and the same machinery bites just as hard. If an officer suspects drugs rather than drink, there's a roadside swab test, and at the station, you can be required to provide a specimen for a drug test in exactly the same way. Failing or refusing that without a reasonable excuse is the same serious offence with the same kind of consequences. And this catches out a particular group who genuinely believe they're in the clear. People on legitimate prescription medication or those using cannabis prescribed for a medical condition. Being lawfully prescribed something is not, by itself, a defence to driving while impaired by it, and it is absolutely not a reason you can refuse the test. If you're on medication that could affect your driving, that's a conversation to have with your doctor and pharmacist long before you're ever at a roadside, not an argument to have with an officer at one. Read that against the American advice one more time. Over there, the theory is, refuse, deny them the evidence, and maybe they can't make the case. Over here, refusing doesn't deny them anything, it hands them a complete, separate offence that carries the same ban as the thing you were trying to avoid. You didn't dodge the bullet, you reloaded it and gave it back to them. And there's a cruel twist on top. If you blow, and you're only just over the limit, that's often the difference between a short ban and a long one. The reading matters, the amount matters, there's room to mitigate. But if you refuse, there's no reading to be lenient about. The court can't say, well, he was only marginally over, because you gave them nothing to measure. Refusing can therefore land you a worse outcome than blowing and failing would have. People genuinely do themselves more harm by refusing than the drink itself would have done. So what actually goes wrong in that moment at the roadside? 3 things, and I've seen all 3. The first is refusing on principle. The person who's had nothing, or almost nothing, and is so offended at being suspected that they fold their arms and say, I'm not blowing into that. They think they're standing on their rights. They're not. They're committing an offence, and they're about to be arrested for it, when a simple breath they'd have passed easily would have ended the whole thing in 90 seconds. The second is the soft blow, and this one is sneaky. People think that if they half blow, or blow around the tube, or make a show of trying but not really committing, they've technically cooperated. They haven't. Failing to provide a proper specimen is treated exactly the same as refusing. The machine and the officer both know what a real sample looks like, and I tried but couldn't quite manage it is not a get-out unless there's a genuine reason behind it. A pretend blow is a refusal with extra steps. And the third is the mouth that won't stop. The panic talking. I've only had 2, honestly. Well, 1 pint, but that was hours ago. I'm fine to drive, I do this all the time. Every one of those is you doing the prosecution's job for them, putting admissions on the record that the officer writes down and that turn up in court. You are not obliged to give a running commentary on your evening. The sample is required, the confession is not. So, here is the approach and the sentence. When that device comes up and you're asked to provide a sample, you keep your hands calm, you keep your voice level, and you say something to this effect. I'm not refusing, I'll provide the sample. Can I just check, is this the roadside screening test or the evidential test at the station? I've no medical reason I can't provide a breath sample, and I'd like to speak to a solicitor. Say it once, calmly, provide the sample you're asked for, and otherwise, keep quiet. Now let me pull that apart because every piece of it is doing a job. I'm not refusing, I'll provide the sample. That is the single most important thing you can say, and it's the exact opposite of the American script. You are stepping around the entire refusal trap in one sentence. You are complying, because compliance is what keeps you out of the failure to provide offence. Whatever else happens tonight, you have not committed the separate crime. Is this the roadside screening test or the evidential test at the station? This shows you understand the two stages, and it quietly keeps the officer precise about what he's requiring and when. It's not defiance, it's clarity. And it signals, without a word of aggression, that you're not somebody who's going to be muddled about your own position. I've no medical reason I can't provide a breath sample. This is a small, honest sentence that does something clever. The only real defence to failing to provide is a genuine, reasonable excuse, almost always a real physical or medical inability. By stating plainly that you don't have one, you're being straight, and you're removing the temptation to invent one later, which never works and makes everything worse. But, and this is why the wording matters, if you genuinely do have such a condition, this is the moment you say so, clearly, at the time. And I'd like to speak to a solicitor. At the station, you have the right to free, independent legal advice, and you should always take it. A solicitor is where the real defending of a drink-drive case happens, not by refusing a test at the roadside, but afterward, on the procedure, the calibration of the machine, whether the requirements were properly made, whether your rights were respected. That is the battlefield, and you want a professional on it. Asking for one early puts it on the record and slows nothing down that matters. Learn the shape of it the way you'd know your own registration. I'm not refusing, I'll provide it. Which test is this? I've no medical reason, and I want a solicitor. Now this is exactly the reason I put the Know Your Rights handbook together. Everything I do on this channel is one situation at a time, and that's useful. But what people actually need is the whole map. What the police can and can't do at the roadside, at the station, and at your door. The exact words for each moment, and the actual law underneath them. So you're never running on advice built for a different country. It's written in plain English, for a person, not a lawyer, and it's the same guidance I'd give my own family. I'm not going to give you a hard sell, the link's in the description if you want it, and everything you need to take the first step is right here in this video. Now let me walk you through what actually happens if you're arrested and taken in, because the station is where people fall apart, and knowing the shape of it in advance is half the battle. When you get there, you'll be booked in by a custody officer, and you'll be told your rights, including your right to free legal advice, which you take every single time, no matter how sober you feel or how much you just want to go home. Then you'll be required to give the evidential breath sample on the larger machine. You must give it. But here's what a lot of people don't know. In certain circumstances, the law allows for a blood or urine sample instead of breath. For example, if the breath machine isn't working, or if a doctor says there's a medical reason, or in some cases at the officer's discretion. You don't get to freely pick your favourite, but if breath is genuinely a problem for you, this is the ground on which an alternative gets discussed. And throughout all of it, the same rule holds that held at the roadside. Provide what you're lawfully required to provide and say as little else as possible. The custody suite is full of microphones and people writing things down. Your solicitor is the person you talk to. The officers are not. And there's one more thing about the station that I want you to hold on to, because it's the reason refusing is so pointless. The evidential machine is calibrated, it's checked. There are records and procedures around every reading, and that is exactly why the real defending of these cases happens there and afterward, on paper, and not by you being clever at the roadside. Was the machine in proper working order? Were the requirements made correctly and in the right order? Were you cautioned properly? Was there a delay that mattered? Those are the questions a good solicitor asks, and any one of them can matter enormously. You throw all of that away the moment you refuse, because a refusal offence doesn't care what your reading was. There is no reading. You've swapped a case that can be argued for one that mostly can't. Now, what does the officer say when you do this calmly and correctly? Usually very little, because there's nothing to push against. You're cooperating. But two things sometimes come up, and you should know how to hold them. The first is pressure to talk while you provide. So how much have you had tonight? You provide the sample. You do not answer the question. A simple, "I'd rather not say anything until I've spoken to a solicitor," is complete, and it is not refusal. You can decline to chat and still blow into the machine. Those are two entirely different things. The second is the suggestion, sometimes gentle, sometimes not, that it'll go easier if you just admit it now and skip the fuss. It won't. Admissions don't earn you leniency at the roadside. They earn the prosecution an easier file. Be polite, provide the sample, and keep the talking for the solicitor. Now, the part I told you to stay for. The one narrow situation where you genuinely can decline, and why you almost certainly can't use it. The law does allow for a reasonable excuse for not providing a specimen, but the courts have drawn that line extremely tightly, on purpose, precisely because otherwise everyone would claim one. A reasonable excuse is essentially a genuine physical or mental inability to provide the sample, a real respiratory condition that means you physically cannot produce enough breath, for instance, or a genuine medical or psychological state that makes it impossible. It is a question of genuine inability, not of preference. I didn't fancy it. I don't trust the machine. I wanted to wait for my lawyer. I was too upset. None of those are reasonable excuses, and people who reach for them get convicted anyway, having now also looked evasive. So here's how to hold that correctly. If you have a genuine condition that affects your ability to provide a breath sample, you say so plainly, at the time, and, this matters, you don't just go silent. You make clear you are willing to provide an alternative, like a blood sample, if you're medically able. Willingness is everything. The offence is failing to provide. Showing you're trying to comply and explaining a real medical barrier is the honest version of your rights. But if you don't have such a condition, and the overwhelming majority of people don't, then the reasonable excuse door is not for you, and trying to force it open just adds a coat of dishonesty to a conviction you were going to get anyway. Let me play the whole thing out, so you can hear how it sounds when it goes right. Blue lights, you pull in, engine off, window down, hands on the wheel. The officer says he can smell alcohol and he's requiring a breath test. You don't argue, you don't explain your evening, you don't fold your arms. You say, "I'm not refusing, I'll provide the sample. Can I just check, is this the roadside test or the evidential one? I've no medical reason I can't provide, and I'd like to speak to a solicitor." You blow, properly, into the roadside device. If you're under, that is very often the end of it, and you're on your way. If it's positive, you're arrested, taken to the station, and there you provide the evidential sample, still calm, still saying very little, and the moment you're at the station, you speak to the duty solicitor, who is free, before you answer any questions about your night. You have committed no refusal offence. You've given the machine its sample and given the lawyers, not the roadside, the job of defending you. So let me bring it together. There are two tests. The roadside screening test under Section 6, refusing it is an offence, and it just gets you arrested anyway. And the evidential test at the station under Section 7, refusing or failing that one is treated as being over the limit, with up to 6 months inside, an unlimited fine, and a mandatory 12-month ban. Being genuinely sober does not protect you if you refuse. The refusal is the crime. So you do not refuse, you do not fake a soft blow, and you do not narrate your evening. You provide the sample, you state clearly you've no medical reason not to, and you get a solicitor. The fight happens later, properly, with a professional, never at the roadside. If this was useful, do two things for me. Share it with anyone who drives, because the American advice on this is everywhere, and over here it is genuinely dangerous. And one person watching this might be the difference between a friend keeping their license and losing it for a year. And subscribe, because I take one of these situations apart every week in plain English, so that when the moment comes, you already understand the machinery better than most of the people operating it. I'm Oliver Bennett. Don't refuse, stay calm, and I'll see you in the next one.